Despite constitutional guarantees of equal protection of the laws and voting rights, African Americans faced discrimination, segregation, and disempowerment throughout the country. Jim Crow was going strong in the South, with everything from schools to water fountains segregated on the basis of race. Voting rights were limited through the use of poll taxes, literacy tests, and brute force. Lynchings, although on the wane compared to the earlier part of the century, still terrorized the African American community. These conditions, plus the lack of economic opportunity in the South, triggered the Great Migration of African Americans from the South to the northern part of the United States. The Great Migration started after World War I and continued apace after World War II. And these migrants encountered both economic opportunity and also intense discrimination and segregation in the northern part of the United States as well. In that same time period, in the mid to late 1940s, the civil rights movement was in its early stages. From the beginning of the 20th century, there were new organizations founded to promote racial equality, including the National Negro Congress and the NAACP. There were new leaders, including A. Philip Randolph of the National Negro Congress and W.E. Du Bois of the NAACP. These civil rights leaders in the United States understood the promise of the Universal Declaration that was being drafted, and especially Article 7 of the final product, which says, all are equal before the law and are entitled without any discrimination to equal protection of the law. All are entitled to equal protection against any discrimination in violation of this declaration and against any incitement to such discrimination. When the Declaration of Human Rights articulated in a more fulsome way on the international stage, the same promise of equality made by the U.S. Constitution, and civil rights advocates in the United States saw an opportunity to use the debate and adoption of the Universal Declaration to pressure the American government to live up to its own purposes. There's virtually no argument that the rights articulated in the Universal Declaration would be directly enforceable in the United States. Indeed, the Declaration is a state principles and not an agreement that imposes by obligations. Rather, the domestic civil rights movement in the United States used the drafting and adoption of the Universal Declaration to generate international pressure on the United States government to change its own ways. How did they do that? While the UN Commission on Human Rights was drafting the Universal Declaration, civil rights leaders petitioned the United Nations to more forcefully acknowledge widespread discrimination in the United States. They filed 2 petitions highlighting racial injustice in the United States. The first was timed just months after the UN Commission on Human Rights was established in 1946. Submitted by the National Negro Congress, the petition, quote, defined racial injustice in the United States as a test for the effectiveness of the newly formed United Nations. The second petition, written by W.E.B. Du Bois for the NAACP in 1947, was entitled An Appeal to the World, and it presented facts about lynching, segregation, and the growth inequalities in education, housing, healthcare, and voting rights. These petitions represented a substantial expenditure of finances and resources by the nascent civil rights community in the United States, which signified the importance, in their view, of generating international pressure. And although the petitions did not affect the final product of the Universal Declaration itself, they were written with an eye towards the ideals of that document. And while the petition, in fact, rejected the United Nations, the NAACP was getting requests from around the globe for copies of the petition, An Appeal to the World. So the fact that the Universal Declaration's drafting provided a forum for these civil rights groups to come to the United Nations resulted in international pressure on the U.S. government to action. For example, historians have found that the pressure that resulted from these petitions contributed to President Truman's decision to establish the President's Committee on Civil Rights, December 1946, which, as far as I know, is the first time since the Reconstruction that the executive branch gave any concerted thought to the question of civil rights. That presidential committee published its seminal report called To Secure These Rights in December 1947, proposing a number of domestic civil rights reforms. Were it not Truman administration's sensitivity to pressure derived from international human rights debate, it's not clear that these domestic reforms would have been on the table at all. The Truman administration's sensitivity to international pressure also manifested in its approach to civil rights litigation in the courts in the United States. The administration participated in several civil rights cases as amicus curiae, which means friend of the court, which in legal speak just means that they asked the federal court to take special cognizance of the administration's position on civil rights cases. For example, between 1947 and 49, so just before and after the Universal Declaration's adoption, the administration offered its opinion in two race discrimination cases, Shelley versus Kramer and Hender versus United States. The former concerned restrictive property covenants, the latter concerned segregation in interstate rail cars. And the argument that the Truman administration made in each case developed in conjunction with the State Department, and it emphasized that the United States had embarrassed in the conduct of foreign relations by acts of discrimination taking place in the United States. These were the first cases in which the federal government had intervened in a case in which it was not a party for the purpose of advocating civil rights. And it did so with an eye clearly focused on the United States, on the United Nations, the international community, and the national pressure generated in response to the Universal Declaration of Human Rights. The same can be said of the administration's position Brown versus Board of Education a few years later. Also in that case, the government emphasized that the segregation of school children based on their race is one of the practices that has been singled out for hostile foreign comment in the United Nations and elsewhere. So at bottom, the international community's pressure on the United States spurred the Truman administration to take positive steps on civil rights in both the political and the legal realms. What was the origin of that international pressure that was felt by both the president and the courts? In part, at least, the pressure originated with the National Negro Congress and the NAACP's petitions to the UN Commission on Human Rights in 1946 and 47, as that body was drafting the Universal Declaration of Rights. The strong stance of the international community on questions of equality enabled the domestic civil rights movement to mobilize that community and use it to pressure domestic actors. So the Universal Declaration of Human Rights played an important supporting role in the civil rights movement in the United States. It was a means to an end. The international consensus about equality and non-discrimination, the tool that civil rights leaders use to shape domestic constitutional litigation. Thank you.
Great. I basically just had some comments on what some of the challenges are moving forward for the Declaration of Human Rights, and think about the place of the UN Declaration in the context of schools and advocacy work for securing human rights around the world. So we don't have a copy of the Declaration. It has a wide number of rights, as many are familiar with. I brought my handy copy right here. If anyone has a question, I can look into the text for you. But basically, when we look at the UN Declaration, as Jen mentioned, it has its history and its roots, particularly in the 1940s, and really as a reaction to the Holocaust in particular. Of course, the actual conceptual and philosophical origins of the discourse of rights and the language of rights goes back farther. And even the very terms we use have changed over time. Whether it's rights, human rights, natural law, there are a whole set of complex issues about how to ground and how to found the language and rights that we use today. The UN Declaration is interesting because it doesn't really get involved in these debates. I think in a lot of ways it's a reflection of the fact that these philosophical debates have, in many respects, hit some of an obstacle. There's a lot of different ways of grounding rights, but there isn't fundamental agreement on the actual basic structure of how to justify them. And that really is a reflection more than anything else of the multiplicity of ways of doing this. But ultimately, human rights are grounded on some kind of conception of human dignity. How we can conceive of human dignity obviously depends on particular religious, secular, and cultural traditions. But there is a portion of human dignity that effectively says that human rights are rights insofar as they are certain properties or attributes that affect moral worth. So we can think of it in that way. And if we think of it in that way, we can understand that and the types of human rights that are identified in the Declaration. I'm not going to go through an actual account all the different rights that are laid there, though I think in the context of the conversation, we can certainly have that discussion through Renee. But effectively, when we think of the Declaration, what we find is it really divides itself in a cluster of different types of rights. There's a cluster of rights that deal with civil and political issues, which really concern bodily integrity, freedom of the individual, and the ability to exercise autonomy. This is what's normally in philosophy is understood as so-called liberals. It quite captures the complexity of what's found in the Declaration, but nevertheless, it does focus to some extent. There's also a second cluster of rights that deal with social and economic issues. Whereas the first cluster of rights, civil and political rights, I think are probably the most accepted and widely implemented set of around the world, even if they're recognized only in the breach sometimes. Issues of social and economic rights have not made the same types of advances around. Even in our own country and states, we see a struggle over understanding how far our issues of welfare and protection of a variety of different of social rights have actually been secured. But in any case, there's a whole set of social and economic rights that are accounted there. When we look at the UN Declaration, we see basically kind of a cluster of different features that are associated with these different rights. First of all, it's worth noting that the understanding of human rights in the Declaration, really what they do is identify a core set of mechanisms for implementing and securing what I understand as being basically human flourishing. So it's really focused around securing some conception of human flourishing that deals with social political issues and deals with social and economic issues. Secondly, the rights inside the Declaration are large individual rights. That is, rather than focusing on collective rights, it focuses on individuals and the rights that individuals have in relation to the community and to one another. It's not excluded, understood in that way. Thirdly, the rights laid out in the Declaration are independent and indivisible, which means it's not a menu. It's not the kind of thing that we can select certain rights, or a state cannot select certain rights to protect and ignore the others. It's not constructed in that way, but they're meant to be fundamentally interconnected with one another. And lastly, the rights are of course universal. They're humans, but the primary obligation to recognize them falls on states. The duty to enforce them falls on state, and that's just a feature of the world we live in. That was recognized in the very beginning. In fact, the United Nations, of course, is understood as a community of states. And there's a certain I built into that. The biggest violators of human rights are the states, and then they're, of course, tasked with protecting human rights as well. But in any case, the option falls on states. So where are we? If we look at the UN Declaration of Human Rights, and we also look at a kind of a companion convention that was passed at the same moment, which is the United Nations Convention on the Prevention and Punishment of the Crime of Genocide, a big wordy title, which is normally understood as the UN Convention on Genocide, died into effect in 1951. It was passed in 1948, basically one day before the UN Declaration of Rights. If we look at these two twin documents, what we see essentially is an expansion of the understanding of what obligations states have towards their people. And it really marks a significant moment, a significant break in how we actually prioritize the universality and protection of individuals vis-a-vis the rights of the state. Now, there's a much longer, complex story that gets told here. Maybe we can get into a Q&A, but it is an important moment. When we look at these two documents together, however, we see that in the Cold War in particular, the recognition of universal human rights, particularly protection against genocide, was, if any, only observed in the history. The nature of the way the Cold War was set up was it was very hard to get the UN to be a major actor in the protection and advancement of human rights. This has changed significantly, of course, as I mentioned earlier. There have been really enormous advances in securing civil and political rights, less so in social and economic rights. But we still face a number of challenges. And I just want to lay those out, and then I'll end my comments. The first challenge is one that's been with us since at least the beginning of this failing system, but certainly throughout the 20th century and through today, which is the challenge of how to balance question national sovereignty with universal human rights. So how does one balance the idea of universal basic rights for individuals, and states also have a recognized right to control their own state of affairs? From the perspective, I think it's important to have a little bit of humility here. From the perspective of us sitting in the United States, it's very, very easy to condemn practices in other countries. If we were having this conversation in the Global South, however, we'd be a little skeptical of the United States and Western powers to tell us what to do. The idea of national sovereignty is an important principle, and the balancing of these questions continues to be a major challenge. We can talk a bit about ways of thinking around that. This is also connected, of course, to the limitations of the United Nations, and particularly the Security Council as a major agent for securing and protecting rights. So this continues to be launched. Aren't easy ways to get around this. There, of course, have been enormous successes. I think there is a space for securing and developing the ability of regional actors to advance human rights. So whereas the UN continues to face a number of challenges on the most pressing cases, be it Myanmar or Yemen, Central African Republic, etc., there are regional organizations that have had some success. The African Union, for instance, when it comes to mass atrocities, has made enormous successes in pressuring neighboring states or member states in securing human rights. The Organization of American States has been pretty successful. There are challenges like Venezuela, etc., but it's really emerged a major international regional act. So we need more attention on regional actors and also civil state pressure. An additional challenge, of course, is the particular historic moment where we are right now. The United States, its place as a leader, advocacy of human rights, continues to fall back. And this is because of a president who doesn't recognize the important human rights. We have a president who's a hardcore nationalist, doesn't really care about international law. This largely is pretty ignorant of happening around the world. What this effectively has done is that it's given the place of thinking about foreign policy to a cadre of actors within the administration who are very hostile to human rights. So I'm thinking particularly of John Bolton, right? We can have an interesting conversation about the place of the International Criminal Court with Bolton, he said, right? But it's not only about the U.S., there's also been a rise in liberalism around the world. So I just mark that briefly. Some other points. I think the topics that the Declaration of Human Rights really is some steps in addressing, but really isn't an app. Some major challenge topics in the future include questions of environmental justice and thinking about climate change. These are questions where actual locus of obligation to secure protections of environmental rights, it isn't clear where it falls. We would say the global community, national community, but that's a little bit like nothing. What's understood right now. So that's a challenge. And secondly, another major challenge thinking about collective and cultural rights. It's a third cluster of rights that is probably the least developed. And this is particularly important for indigenous movements of the world. So if the first two generations are civil and political rights, then social and economic rights, the thumbnail sketch, which is accurate as far as it goes. The third generation are these collective indigenous or collective rights, the cultural issues, which is particularly important to indigenous people. I'm probably short on time. I'll probably stop here. I'm happy to say a little bit more about where we are in terms of advances, but also challenges and about the prevention of mass atrocities and how this connects to international law. But perhaps we can make more comments a little bit later. Thanks.
Good evening. Thank you to the Institute for having me on this panel. I probably look at the Universal Declaration of Human Rights somewhat differently from the fact that I do come from the Global South, and I had an advocate in the Global South. And in the Global South, such as a country such as the Philippines, the Universal Declaration of Human Rights is a legally binding document. It is actually the basis for any individual to go before the Philippine Supreme Court without needing to resort to domestic legislation or any other constitutional norm. They have used it repeated as the basis to constrain government action. So from that perspective, even early on as a litigator 15 years ago, when we didn't have anything, we would go with the UDHR. And some of the landmark jurisprudence that has come out from the Supreme Court, especially on matters of forced disappearances and violation of indigenous people's rights, have come out that action of the Universal Declaration of Human Rights. So the way that I UDHR, at least as a scholar, and also from the corpus of what I've observed in the last 15 years, it has gone common standard of achievement to what is a transformative internalization in the Global South, in the Global North, through legal norms as well as through the operationalization of standards. And it's anchored commonly on a fundamental, even if it's debated, it's a fundamental acceptance that this instrument is anchored on a recognition of human dignity, however much we may dispute it in whichever part of the world that we're from. So I have 6 points to make on this development to take a look at what's happened in the last 70 years in the international human rights system. And as I said, I've adjusted and alluded to it. First point is there has been multi-level internalization of UDHR in many jurisdictions. I cite the Philippines as one example. It's a legally binding document. The South African Constitution, which places its emphasis on human dignity in Article 1 of its constitution, drew heavily from the understanding of human dignity as established in the Universal Declaration of Human Rights. It was important with apartheid AFA to South Africa to establish that fundamental reading of the Constitution as a rights-based constitution. There are also other jurisdictions that more liberally use the UDHR either as a source or possible evidence of customary international law on the subject, and increase as you take a look at the comparative jurisprudence coming from Europe, as well as in places like Australia. The UDHR is very much cited now by the courts, the evidence that there is custom on, say, the rights of stateless people, on the rights on economic, social, cultural rights, long before any of these states actually believe the parties to the major human rights treaties. Which leads to the second point. The UDHR is important, the anchoring document to establish, as Ernesto pointed out, the interrelatedness of human rights and in universality and its indivisibility, meaning there could not be any compartmentalization of the understanding of how we achieve human rights. You cannot just take a look at civil and political rights on the one hand and try to relegate economic, social, cultural rights on the other. When the International Bill of Rights was concluded in the 1960s, they were concluded together, both the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, Cultural, both conventions, which are legally binding treaties for the states parties to these conventions, drew from the anchoring document, which was again the injection of dignity based on UDHR. So it's interesting to see how the interrelatedness has developed within the last 20 years, because today we live in an era where at least for human rights practitioners and policy professionals, we live in the Agenda 2030 Sustainable Development Goals era, where Sustainable Development Goals 1 to 17 no longer make any hard distinctions between civil and political rights, the need for rule of law and inclusive societies, peace-based societies, and the terms of economic, social, cultural rights, matters such as the right to water, which is not specifically provided for in the International Covenant on Economic, Social, Cultural Rights, but through practice has evolved as one of the core economic, social, cultural rights that states have grown to accept and individual peoples themselves rally towards. There's also, as I totally agree with her. So there's a nexus now, a really established nexus within environmental rights, going from, again, annexed to the notion of human dignity is the concept of stewardship, of how the ecosystem we inhabit, how we're all moving towards what is now the Anthropocene, where human intervention is possibly the big cause of change to our natural environment, unlike the previous Holocene era. The United Nations now builds the SDGs with the notion that everything we do has that direct impact. That's why human rights must be viewed from an ecosystem of interrelatedness. It's a series of responsible actions that we do, not just towards states, between states and governments, but towards each other as well as towards our environment. This leads me to the third point. There has been, I point to the global South because in the big human rights cases in the 1970s, the 1980s, 1990s, the heyday international criminal law, with the big case at the International Criminal Tribunal for Yugoslavia, for Rwanda, and then for the International Criminal Court. Those were the big, and of course the Nuremberg Tribunal, those are the big cases involving civil political rights, and the discourse for such a long time rightly focused on achieving peace and order in societies by ensuring that these basic and fundamental violations of civil and political rights were addressed. in the international system by providing remedies. But we've seen, at least since the 1990s, when the whole debate on the right to development came about, the 1986 Declaration of Right to Development, the global South, which was in transition, and many of societies are in transition to different forms of government, were more willing to sign the International Covenant on Economic, Social, and Cultural Rights than they were the ICCPR. So in China, where I used to teach human rights law, everybody understood we accept International Covenant on Economic, and Cultural Rights. And one of my good friends and colleagues there about because it's less controversial, because it focuses on development, it focuses on growth. A true understanding of economic, social, cultural rights would have shown that it's actually more controversial, because it involves allocation of state resources, involves decisions on where states will protect, respect, remedy, or facilitate the provision of essential goods and public services. Anytime there's that kind of fissure on property, on the allocation of fiscal funding and sources, and who gets to be supported by government resources, it's going divisive, which is why you've got land grab issue. You've got issues on access to water or access to utilities. So the global South, at least in the early part of the 2000s, particularly the organization that I work with, the Association of Southeast Asian Nations, they did not hesitate, 10 member states did not hesitate to sign its own ASEAN Rights Declaration with an extensive on economic, social, cultural rights that it basically copied both from the EHR and the International Covenant on Economic, Social, Cultural Rights. Because the prevailing notion was these are standards of achievement towards progressive realization. They would not be as confrontational as, say, the hard course of civil and political rights. So we've seen the mainstreaming take place in development strategy for many states. We have our national sovereignty to determine our respective development, but we will do what we can to try to internalize economic, social, cultural rights. But the debate precisely is how you go about, say provide the right to an adequate standard of living. That means many things to many people. I mean, my one example today was this past, there was a power outage, and for me it was quite normal because I grew up in the Philippines, where lucky if we had electricity 4 hours a day, but consternation over my entire neighborhood because power was lost a couple of hours. And then I realized it's a perspective matter. The fourth point I want to bring up in the transformative internalization of the UDHR is now we are faced with the challenges of the proliferation of the rise of strongman governance, and how they have also co-opted and transformed the notion of what is the rule of law into rule by law. If you notice many of the pronouncements of leaders in Hungary, the Philippines, Myanmar, DPRK, Turkey, China, now there's a constant law-based justification for imposition of measures that ordinarily would be so repugnant and repulsive to all of us. It's usually done in the name of national security. It's usually done in the name of sovereignty, us as a people determining our own fate, or at least co-opting the language of self-determination, which didn't used to be a right that appertained to states. It appertains to peoples. And yet we see these strongman leaders say it's part of our sovereign right, the fundamental right in the international system to protect human rights for our own peoples. And if our own people don't want it would not be for anybody else to impose these rights. They're a threat taking place to what in terms of we understand by universality. And it's been taking place because even the UDHR language of it is also being deftly co-opted by many regimes today. The fifth observation is also we've never seen these many challenges to the verifiability of human rights fact-finding. We have never seen an era where there's so much more pushback against human rights bodies based same sovereignty argument, or there's a refusal to operate, as in the case of the Rohingya investigation, where Myanmar outright says this is an internal matter, even in terms of the detention of two journalists, Reuters journalists in Burma. The party line, even from Nobel Prize winner Aung San Suu Kyi, was this was a case that's decided by other, so we'll leave it at that. There could have been any possible pathology because there was a court that did it. Duterte in the Philippines does what he does in the extrajudicial killing drug war, but he thinks it's been legalized and anesthetized, sanitized, because it's all done under the cover of protecting civilians under the rule of law. So because of that, in this era where there's been a proliferation of challenges based on competing facts, or never heard this phrase before, alternative facts. It used to be lawyers had a process of fact finding, and this is, we don't know what really happens. Let's try to subject it to the test of what we all used to know was due process. But now, with the advent of technology and instantaneous communication, everybody has an opinion on what has happened. It's so much more. It's so much easier to discredit the long, painstaking investigation that has been done by established human rights bodies. Just say they're biased, they're being funded by somebody, or they have a particular Western bent, and they're just out to go after Global South for something. So while we've seen on the one hand that this international human rights system has seen more decentralization, which is welcome, and diversification, also from what to be just a state-based system. States had to agree whether or not they could be subject to procedures. Now we allow more participation from civil society, from peoples, from organizations. We also see correspondingly challenges to the legitimacy of the international human rights system. And states have pushed back more. And in this respect, I'll point to the United States, where Ambassador Nikki Haley just, I think a few months ago, said the United States has to withdraw the Human Rights Council. The word the Human Rights Council is against. It is against certain allies of the United States, that there's a very particular bent. And so we will withdraw support instead of underwriting the costs of the work of the Human Rights Council. There have also been challenges to international human rights tribunals. It used to be 1998 when the Rome Statute was passed. It was the big heyday of finally, there will be no place on earth that perpetrators of mass atrocities could ever hide from, or could ever hide in. But now there's been a lot of effort to discredit the work of the International Criminal Court, which I'm sure Ernesto has a better opinion of it than I do, and at least a deeper opinion of it than I do. But there's been a steady pushback, and the undercurrent of that is that these institutions are illegitimate, they're outworn because they're divorced from reality, they're at The Hague, they don't really know what local justice is, and there's some currency to that. But the price of rejecting the international has been transferring what used to be our reliance on external accountability to purely domestic accountability. And from my standpoint, while that worked for us in the Philippines back in the day when we could go to the Philippine Supreme Court based on the Universal Declaration of Human Rights, today I'm not so confident, especially when strongman gun governments get very creative about how to pack courts, or get creative about how to delay process and still call it rule of law. But I'm going to conclude on something a little bit more optimistic, which is I've seen, at least from the development of DHR since its genesis, a welcome openness to more dispute prevention and resolution strategies. While today our constellation of rights tribunals with their established jurisprudence, the European Court, the Inter-American Court of Rights, the African courts as well, the ICC, ICJ, there is a sophistication that has emerged from the jurisprudence. It's not perfect, but there's been innovation in terms of what to look at by way of reparations and what the possible remedies can be for victims beyond a straight compensation payment. But there's a lot more emphasis on arguments of memorialization, of never forgetting what has happened. ensuring that education takes into account how human rights atrocities have affected whole societies. There's also attempts to take a look at whether or not human rights victims, incipient, but some efforts, human rights victims directly sue corporations without having to depend on a state to take up their cause, or without having to depend on states allowing corporations to be sued. It's happened in the particular case of Bangladesh, where in the Bangladesh court after the Rana Plaza tragedy, basically garment sales workers were killed with the collapse because of the factory was not compliant under building standards. There was a rush to reach an immediate cooperative solution that enabled all claimants to bring their claims directly under the auspices of the International Organization and the dispute settlement mechanism that was devised by both the labor unions as well as international business. And they've reached judgments more expeditiously and been able to enforce them more expeditiously than I would say many of the international human rights tribunals. We're also starting to see that in the areas of climate change, where I can get into later, but that's going to be over sort of the discussion. There have been more bespoke mechanisms to derive accountability, including beyond the traditional scope of the optional protocols to the major human rights treaties, where it was a standard protocol procedure or communications procedure just to obtain state reporting on what has been alleged. There are now more efforts to go look at the remedial side and not the declaratory side of what happened, also what we can do going forwards. It's not a perfect ecosystem, but I'm pleased with the fact that there have been more actors and as more challenges arise. But I'd say transformative internalization is the best bet of the UDHR.
Ladies and gentlemen, thank you very, very much. It's wonderful to be here. I want to thank the Institute for the invitation and Irish Studies. And what I'm going to sort of speak about is a cultural response to the civil and human rights deprivations that existed in Northern Ireland during the Troubles and during the period that preceded the Troubles, from the foundation of the Northern Irish in the 1920s. And I'm going to draw on my methodology of documentary making. I'm documentaries, I've written books on Northern Ireland and particularly on Derry City. And I'm going to focus in particular on the person of John Hume, because yesterday evening, very facilitated, we had a screening of my film In the Name of Peace, John Hume in America. As Aaron rightly said, he was one of the earliest speakers here at the Crook Institute. He's also the only person ever to have been awarded the Nobel Prize, the Martin Luther King Prize, the Gandhi Peace Prize. So he's a figure not only in our history, but in world peacemaking. So the way of some background and how I became involved, years ago, back in 2006, I interviewed Seamus Dean for an academic journal called Japan. And I know founding directors of the Irish Institute here. And I put to him that as a boy growing up in Derry City in the post-war years, he couldn't have been aware that his generation, being the first generation beneficiaries of mass education in Northern Ireland, and that his generation would have such a transformative effect on the political and the legislative condition in Northern Ireland. And his response is as follows: in Derry, you wouldn't have got a job. There weren't any jobs to be had, so my parents were very anxious that go to school. And they actually recognized that a cohort of CAF kids going to school was what was going to break Northern Irish state. We know 2018 that the Northern Irish state is still an ongoing thing. It still exists. But what I believe Seamus Dean was addressing was the Northern Irish state as it existed from inception through to the late 1960s, through to the civil rights movement, and how the hegemony of the Unionist Party and Unionists generally had done so much to damage the Catholic minority in the north, limit its possibilities. And that's where I really begin the John Hume America story, his emergence as a political leader in Derry and his emergence as a defender of human rights and civil rights. He was doing this in the late 1960s in Derry in tandem with being a member of Parliament of Northern Ireland, as it was known then. He was elected first to the Parliament of Northern Ireland in February 1969. And once got into the Parliament of Northern Ireland, he immediately started to use arguments that really illustrated the bankruptcy of the Northern Irish parliamentary system. Like Andy had done in the 1980s, he cited the principles of the British government that the British government purported to hold and demonstrated that they were being honoured in the breach. And he also furthermore, and I'll quote some of his arguments here, he said that when this came into being, when the state came into being, was set up on the basis of a sectarian headcount. That having done, the British government said, we guarantee that you can stay with us as long as the majority want to. By doing that, they trapped the unionist population into perpetual sectarianism. In other words, the way in which the boundary of the state, the Northern Irish, had been created, the 6 counties of the Northern State, had been so constituted to perpetuate this cycle of people identified with the British state, really voting along unionist lines, and then creating this nationalist minority, which was always impotent, it's incapable of changing things, even local the level of borough politics in Derry, which is deeply ironic, of course, and because Derry City wasn't a Catholic majority. And that's why I would argue people like John Hume, when he came of it, when he started to agitate civil rights and a new form of democracy in Derry, that's why it was so possible to take changes in Derry. In the late 1960s, the civil rights movement emerged, as I've said. It did have very significant gains, but it also was countered by very significant state repression first with the Northern Irish state, and then that was in turn consolidated by the arrival of the British Army on the streets of Northern Ireland, and a process of internment without trial, all these suspensions of human rights. I mean, these violations were subject to court cases. The Strasbourg cases in 1976, one example where the British government was found being in violation of human rights, of torture in internment camps in Northern Ireland. But the problem, of course, was no consequences ever flowed from this. Yes, there were violations. Yes, it was done in broad daylight on occasions. I'm thinking particularly of Blood Sunday. But the British government and its representatives in the Northern Irish state were never forced to do anything to change the system and the regime. A lot of this was visited upon people who were been proven were entirely innocent and whose culture indeed was the seemed to have been the problem for the security force. Membership in Irish Language Society, membership in a Gaelic Athletic Association, for example, was sufficient apparently to lift people, to imprison them without trial. And this was the Northern Irish state. John Hume was elected to try to change. Now, going, because it's a limited time, I'm going to go into another approach I took in another documentary on Brian Freel's translations. Just to give him background, Brian Freel's play, arguably his translations written in 1979. On the surface was a historical period drama looked at rural unity in County Donegal in the 1830s, but it was deliberately written at the nadir of the Trouble, tried to illustrate something about the cultural divide that existed in Northern Ireland in the 1980s. It was first produced in Derry in the Guildhall. And Freed this very deliberate reasons. He said at the outset in various press conferences and public statements that he was attempting to work himself into the political crisis in Northern Ireland. The politics and the politicians had, in a sense, at that stage, failed to fully confront all the issues, the cultural problems that existed in Northern Ireland, and believed that the use of play as a vehicle to enable people from unionist backgrounds, from nationalist backgrounds, to fully see the complexities of their division that existed in Ireland was a legitimate approach to take. He did this in combination with several other major people in our recent recent cultural history. I'm thinking of the actor Stephen Ray, Seamus Heath, the poets, James Dean of all the mentioned. These people got together, formed a company, a drama company, and a publication company called Field Day. And the inaugural work of Field was indeed Brian Field's Translations, when it opened in Derry in 1980. When in Derry, Seamus Heaney said at the time that the premier translation was, I'm quoting, a moment of civic definition. For Dean, the production took place against the backdrop of Hobbesian civic wilderness that was Derry City at the time. Ray's cost, and Ray is the dedicatee of the play. He played Owen in the major protagonist of the play. He said the production and the performance of the play in the Guildhall, which is basically the city hall of Derry, transformed the Guildhall from being a dead political space to being a live theatrical space. And I think that's a very important dimension to what they were trying to do, to try to get people in the North to see their identity in you and see how it was some way in met with the other tradition. As Declan Kybert, who is now here Notre Dame professor, he said, thinking of the people who produced translations, who were founding members of the Field Day Company, had a big impact in the Belfast Agreement, or the Good Friday 20 years later. It's the same trick that exists in Brian Field's play, heard in the agreement. Not only that two cultures can be an equal party of steam and on, but that a person could be Irish and English together, that identity itself shared, divided, and mixed up. I think that feeds very much into John Hume's political life when one looks at it, because from the very get-go, from 1972, he had written a very small document called Towards a New Ireland, which he invites unionists and invites the British government, invites the Irish government to form part of a new discourse to create a new political cultural structure on Northern Irish in Ireland itself. I'm just conscious of time, and I'd like to play you a clip because some of you, I think, may not have been along to the screening last night. This excerpt from John Hume in America delves into a moment when President Bill Clinton decides to, as he says, trust John Hume's instincts and to really get involved in Northern Ireland and take steps which were intervention to the British government's view of how Northern Ireland should be. So Brandon, if we're okay to play that clip, here we go.
Get support in Congress to do this. And he to legitimize his notion that America should war.
The person I kept asked John Hume, who in the spring and summer of 1993 said, not ready yet, don't get involved, don't give Adams a visa yet. By the fall, the two had married, and Hume saw that Adams needed the support of coming here to the States to talk to the IRA supporters here in the United States to get support for the ceasefire. He could not deliver the ceasefire without the support of the U.S. Then the declaration came, which essentially took away the political reason for the violence of the IRA, because now they had a democratic way to get it in Ireland.
Arable land. Although they are an occupied nation, and their only border is an inland one, they yield to nobody. Their belief the country is an island. Somewhere in the far north, in a region every native thinks of as the coast, lies the mountain of shifting names. The occupiers call it Cape Bassett. The sun's head on, stormers in the east. Drunken Westerners call it the orphan pit. To find out where he stands, the traveler has to keep listening, since there is no map which draw a line he knows he must have crossed.
Thank you very much, Brandon, for that. The specific issue being mentioned there was the granting of a visa to Gerry Adams. And some of you may be aware of the context there that Gerry Adams was at the time leader of Sinn Féin, which had, to say the least, deep links with the IRA. And the IRA designated a terrorist organization. And for President Clinton to take the decision to enable Gerry Adams to come to the United States was very much in contravention to what the British government would have preferred. He did so on the basis of John Hume's instruction that something was changing within the IRA, that they were ready to countenance a ceasefire, but that, as Nancy Soderbergh very astutely points out there, she's deputy national security advisor, that Gerry Adams needs support of IRA's backers, supporters here to broker this ceasefire. At that point, then I use a Seamus Heaney poem, which is a parable from an early collection. And my view of that poem is that Heaney's trying to suggest that different factions within a very divided culture like Northern Ireland have different ways of naming things. And there needs to be some accommodation, some way in which we can come to agreement of how concepts and even places are named. It's such a, it exists, it's a division that exists at this cultural level as well as a political level. It's a poem that made most sense to me, actually. I've seen this film quite a bit, having made it myself. But I had a screening a couple of weeks ago in the militarized zone in Cyprus. And the UN buffer zone exists as a place where people can come together from both sides, journalists, members of the diplomatic community, academics, all kinds of tend to have events in this peace house, as they call it, and they try to have a discussion about, well, how can we into a more unified structure it, in the island that once was culturally and politically unified. And it just made perfect sense to me, that last stanza in Seamus Heaney's poem. There is no line that to know the line that they must have crossed. There's this definite line that has been drawn in Cyprus since '74, and today it's got a 2 checkpoints, just as we had in Ireland. We had a hard board many years during the Troubles, and it requires, I think, the assistance of not politicians but also leader writers, actors, poets, who can do something towards creating a new discourse and a new vocabulary that we can share. So that's my 10-minute view of the role of artists and writers in Ireland. But I don't want to overlay my welcome here. I would welcome your comments and questions about what I've said later. Thanks.
So, audience?
Well, thanks so much for wonderful presentations. My name is Tony. I'm from Uganda, and I'm doing my LLM in International Human Rights Law. My question is basically to Ernesto and Jennifer, any of you can also answer. You talked about the history of the declaration, particularly fact that there had been the Holocaust, and around that time in the United States there was widespread discrimination. And in my view, right now, these are not the main problems right now. Right now, the global problems of human rights are refugees, Islamic extremism, and terrorism. And in my opinion, I think this declaration has not offered much these global issues. And I would take your say on that. And because, there's been another declaration, the Cairo Declaration by Arab states. So in my thinking, maybe there's another deep perspective, another part of the world about human rights. Thank you so much.
Do you want to take a couple of questions? How do you want to do it?
Okay, so who would like anyone else have a question?
My name is Gentile. I'm professor of business ethics in the Mendoza College. I would like to continue the optimistic view of Diane about how the transformative integration of human rights in many different areas. And I'm working business ethics. And so I think a major development last 7 or 10 years is just the UN guiding principles on business and human rights. And that means a move from the state responsible duties of state, according to Ruggie, is still extremely important. But the responsibility of corporations is important and independent of states too. And so, the move from state actors to non-state actors who are responsible for human rights, I think, is extremely important development, which now concerns operations, not only operations, but any type of business enterprises, according to it. And also now it moves towards other non-state actors like churches, universities, etc. And so I'm the optimist out of that development. I would like to know more what you think about it.
One more question in the front, and then I'll turn it over to the panel.
Yeah, Nandar, international student from Burma. Yeah. You talked a lot about what happened in Burma, Myanmar, as one of the highlight pretty much every day. So a little bit of background. Just recently, 100,000 Rohingya were driven out of the country, and thousands of them died, killed, raped, burned. And secondly, there are a lot of peacemakers in Burma and civil society. We come up and talk about recently, which happened is 3 poets come to City House and recite their poems. They got arrested immediately. The third one is those 2 journalists who was accused and then they're badly accused and imprisoned for 7 years. So when talking about transformative internalization, informations, in this we have been trying for the past 60 years or so longer. Thousands of invisible souls. I want you to tell us how to constrain our government's action and their violations of what can we do as a part of a citizen? How can we correct? How can we erect what the government is doing to take the responsibility fully? Thank you. Thank you.
You can start. Okay. Thank you for your questions. I agree with the first question with Tony. Tony. Thank you for your question, Tony. I agree with you that in some ways the declaration, of course, has its origins in the context of various types of atrocities and the very specific types of events early to the 20th century. Undoubtedly, that's the case. Nevertheless, I do believe that the Declaration still has a lot of relevance today. And as my colleagues on the panel have already mentioned, it's really about the interpretation of the various rights and the expansion, filling out of what this entails in terms of expanding the rights and understanding the place of rights today. This may include, for instance, issues of access to water, as you mentioned, a whole cluster of developmental issues. So there is some interpretive elasticity, right? There's some applicability. It's not as if the Declaration is no longer relevant because we have either new challenges or we recognize challenges that have been with us a long time. We recognize them newly now. So it's not the case that doesn't have applicability. I agree with you that the issue of refugees is extremely important. And now we expand it to consider questions of displaced persons, so both refugees as well as internally displacements, as well as people who have become states, such as the case of the Rohingya, among others. The issue of terrorism, undoubtedly, is an important issue. I wouldn't restrict the attention of what the priority questions are today to fundamentally issues of refugees and terrorism. I think it's a broader set of issues. We have, for instance, with questions of weak governments and state failure or state instability around the world, but also, as my colleague mentioned, the expansion of illiberalism. Because I think one of the challenges or one of the mistakes we can make is thinking about problems of human rights fundamentally and only at the level of the nation state, understanding the broader regional and international dynamics that can either exacerbate these issues or mitigate them. So if you look at it like just Yemen or Syria, obvious examples, these are international civil wars, right? So we really have to think about the international context. If we think of Myanmar, Burma, we have to think about the role of China in particular, but not only China, also regional powers as well. So I think these are important questions, and I would just add and reinforce again some points that I made earlier on drawing attention to the importance of other challenges, including environmental challenges and issues of climate change. I don't think that there's one fundamental problem that we face. I think it's a cluster of different problems that reinforce one another. But climate change is going to be a major driver of stability of human rights abuses around the world. It's going to do it in an uneven way, but nevertheless will be a major question. And then fundamentally also, as you mentioned, colleagues on the panel have mentioned, question development. The last point, I'll just say something about cultural specificity that you draw our attention to. You made it as a statement, not as a question, but there is an ongoing debate that existed for a long time, whether the UN Declaration is real universal declaration or it's a declaration that Western declaration has adopted the language of universality and therefore been in other cultures. I'm not convinced that that's the right way to formulate the issue. I think the UN Declaration really gives a whole set of rights that are fundamentally universal rights. That is, people in all cultures and arts of the world can recognize these as fundamental properties that have to be protected in order to secure human flourishing. Now, the issue then becomes how does one implement these? How does one interpret these? It's the question of due process. Due process can look different across different cultures. But the idea of due process is a fundamental human right. The idea of protection of bodily integrity or of conscience look differently in different cultures, but they are fundamental insofar as they're necessary for flourishing. So that's just kind of the point I make. I think it has to be disaggregated by level of analysis, not to be too pedantic.
I would just add, I think that we see similar questions being asked in the international sphere and in the United States context as well. Do we need to amend our foundation documents to deal with new sorts of problems, or are those documents sufficiently capacious to be kind of open to interpretation? And so do we need new documents? Do we need different interpretive methodologies? Do we need to have new actors, as you did, coming to offer their own perspectives, right? So do we need to evolve decision making to states or to private businesses? Do we need to involve other kinds of international actors in discussions about how human rights law or doctrine can deal with new problems? So I think you're asking the right questions, and I think they're being in lots of different contexts.
Let me address our colleague from Burma first, especially since I have a lot of friends who are working in Burma at the moment. The same thing that I tell my students or any of my colleagues is that rights lie dormant if you don't know the stakeholders and the ecosystem in which these rights have to be vindicated. One of my classes here, I'm glad some of my students are here. We've had to imagine how to do it in a world where systems operate very differently. And the same common question of how do we restrain government's actions, the first thing I share with my colleagues in Burma is you know your country better than I do. I can share my experiences of being born in a dictatorship, seeing that dictatorship collapse with the 1986 EDSA revolution. Literally, it was not sitting down tanks. And it was a collective effort by the people who realize that their rights are constitutionally enshrined, that they defend it. But at the same time, I've seen my own home country relapse in de facto dictatorship, bolstered no less by an 80% popularity poll, because for some reason, values have shifted. And I don't know how that happened within the last few years, but it's been happening. There are strategies. And we all know this to a certain extent. We go from a spectrum of trying to see how we can build cooperation as human rights advocates, to trying to see how we can prevent abuses at those local level through cooperation. But when that doesn't work, then we need the blunt punch of accountability, which is where we are now, at least from what I know of what has been reported in Burma. And it's difficult because the UN inspectors are not permitted to come in. The government insisted that this is sovereign matter. On the one hand, international pressure is important. It used to be the United States would rally the Security Council to ask for a specific resolution that would compel investigation of atrocities of this nature. I still hope for something like that from the permanent membership of the Security Council, but other Security Council members will not for it. They don't want too much interventionism in human rights matters. But when you've got a transboundary emergency that you can't fake those videos. You can't fake the videos of what's going on with the. You don't even. Somebody tried to tell me it's just the diaspora of the Rohingya community. I said it's not a diaspora so much. It's outright expulsion and atrocities that are committed along the way. For me, it looks like the second cost. But there needs to be a building of consciousness, both inside and outside, for political actors to move. And the same thing I keep telling my students, you have to know who the stakeholders are so that you first consult with the communities who are affected as to what they need so that this is locally owned justice, and then figure out how to pressure and to move. And believe you me, it's the same problem I have now because I'm counsel for many extrajudicial killing victims in the Philippines. And we have a pending complaint. We succeeded in getting a preliminary examination opened in the ICC. I was heartened to learn just a few days ago that the prosecutor opened a preliminary examination as well into Burma. That will put some pressure to a certain extent. And the other thing also that is tragic, the ongoing of life is we live in an era where where we seem to be desensitized into the barrage of images. Everybody watches this and then let's flip the channel. It's somewhere else. The pressure has to be constant. Values have to be formed. Everybody has to remember what it means to be human. And acts of inhumanity should not be permitted. And so that's what I'm facing in the Philippines right now. Everybody's here thinking about the trade-off of how much they love the expansion of the middle class and forgetting about back alleys where poor people literally are being killed. There needs to be a counterpart values transformation, and I'm more than happy to collaborate, and I have collaborated quietly with colleagues who are on the ground. And all I can say, the long arc of human rights, I have to trust that the arc of moral justice does bend in the end. I thought it bent in the case of the Philippines by 1986, but we're back. So that's a long arc we're trying to do. Which makes me wonder, well, I'm optimistic, which leads me to our colleague's question. I'm probably optimistic because it's reference points on my end. It's the same thing that I've also told my students. In today's era where everything is magnified, social media, it's so tempting to think everything is so horrible right now. It is. You can see some image, it sticks with you cognitively. It's an impression that makes you the world is in a really bad state. But what if you think that for the first time, infant mortality is down considerably for the first time in generations? First time as well, you've got the expansion of opportunities for education in many places where it didn't used to exist. Or for the first time, the diseases that have affected maternal mortality have been virtually eliminated. People talk about the reduction and how, of course, that's not going to happen. There are some places where it's actually happened in the lifetimes of people that poverty has been substantially reduced. So the reason why I say I have some optimism is we are not in the same state as we're in at the time the Universal Declaration of Human Rights was formulated. In 1948, most of the world was in reconstruction and 6 million Jews were slaughtered. We at least have a growing consciousness, even if it is not perfect, as pointed out by our colleague, with what's going on with refugees, Islamic extremism, immigration, and the entire issue, how we deal with these issues. There's been some moving of the needle since 1940. There's still some consciousness, even in the case of the state actors and non-state actors. I can be critical, but at the same time, and I think about the cooperative aspect in the spectrum of what do we to realize rights day to day, that very, very painstaking spectrum when we have been. There are opportunities to cooperate. I mean, I was quite surprised that two of the largest oil companies in the world a couple of days ago agreed to join the Oil and Gas Climate Initiative, where they are obligated, or at least they voluntarily obligate themselves to disclose information about every aspect of their business operation, how that will generate climate change impacts. Whether or not that we're going to materialize, we don't know. But the health that used to be so impossible to fathom, that the private sector would not be involved in realizing human rights as a partner, became more possible within the last 10 years. So churches and universities also extremely, I think we all saw Professor Abrams' fight in Ukraine, where he was there and heard of him before he even came here. He was there pushing freedom of thought, freedom of education before anybody else was going. And it's what I try to balance well, because it's among human rights practitioners and professionals. It's to be in vogue that we should be depressed, and we should always be unhappy about the state of the. What I do tell my students is never be content, never. Don't be complacent about it. But there's no reason why we can't be happy warriors doing the good fight every day, because you have to. Otherwise, it also burns people out without undermining the dignity of what is going on. It also helps us to realize our shared humanity, and that shared humanity is not a perpetual lamentation. It's part of who we are, but it's both lamentation and celebration. So how I reconcile this in human rights and what's going on and more, I think of it as it's the perpetual human condition, but the fight has to be fought, and have fought knowing there's a spectrum of cooperation, to prevention, to accountability, to the innovations that we still come up with to make human rights a daily reality.
If I could briefly add on the question of Burma, it seems to me that when one looks at the South African situation, Northern Irish situation, that when there is a terrible abuse, and there's nothing on the scale of what you've just described, 600,000, but still, when an act is taking place, that when sovereignty is invoked, it's one of the mechanisms that states use to prolong the day we have to confront the realities of their crimes. And of course, time is the very thing that is precious in Burma at the moment. I wonder, I can't really give a theory, but I wonder what can be done to augment the sense of nationhood in Burma, to be more capacious of the people who are being persecuted, because we know from a cursory glance at history that when human rights are suspended for certain people, they'll be suspended for the peoples tomorrow, and to in some way create a mass movement, mass consciousness, and a minimum that these people are not other people; these are our people who are being persecuted. I again wonder, without being able to be absolute about this, but I wonder whether the high-profile people who have made clear their non-identification with what's happening in Burma, whether that's having a thing, and whether that could be built upon our very own Blow of U2 has been clear. Songs, one of the U2 songs relate to "Walk On." Is about Aung San Suu Kyi, and to a good degree, U2 has now repudiated the song, or at least we will not play it publicly because of our stance. And I wonder other people can get involved, because mass consciousness, it's a momentum, and it builds. And whether, as a final thought, the example of the Arab Spring, which is really designated a failure for what happened 5-10 years later, but or not quite 10 years, but 5 years later, the resurgence of dictatorships in the Arab world. But it's still early to say, and the fact that I'm really heartened, for example, to hear that people are reading their poetry and defying laws, and of course very disheartened to hear that they're being sent up to prison. The case of those 2 journalists is an outrage, but it is an international outrage. And yes, I think that, as you rightly say, Diane, the courage of the people on the ground, in tandem with pressure from outside, one hopes that this outrage will be stopped.
I guess we have about time for one more question. And just to let you all know, there is some food across the hall, and this conversation can continue informally. So.
Hello, thank you very much. My name is Damon. I just want to throw an idea out, not so much as a question, but more as a statement, actually. Professor Desio, if I could throw out some terms to you, and specific, like mass, Urmita, Po'an, my brother, my executioner. Of course, these terms mean something to you, because that is the titles of novels by F. Shinil Jose. And I've been thinking a lot about F. Shinil Jose in the last few years, having read his books 20 years ago, because of one theme that really resonated very strongly with me at the time, and resonates more strongly now, which is the susceptibility of intellectuals to be corrupted by social cultural forces around them that led them not to act on behalf of the community and on behalf of truth and justice, but on the ability to get ahead as individuals themselves and their family. And I'm thinking about that a lot, because astonishment, people I've known for 20 years, maybe less time, people who have come to the Filipinos, who've come to the United States and attended Indiana University, done doctoral programs there, for example, onto the Kennedy School of Government, and who are now in powerful positions, for example, in the National University of Singapore, or who are acting as judges in the Philippines today. With absolute astonishment, I have noted that their attitude towards and treatment of the human rights violations by the Duterte administration have to either support those human rights violations, or to write them off as saying it's not even worth talking about, because Duterte is doing other things. And of course, I mean, he's a president, so he does a lot of things. But the point is that it's incredible to see these people. These are not bad. They're not
unintelligent. On the contrary, they're very extremely well educated. But they're not talking about these issues. In fact, they're making the situation worse. And the idea, sorry to talk for so long, but the idea I want to put out here is that it's, to me, one of the threats to international human rights are people like that who are in positions where they could do something, but they're not.
I absolutely agree. I think you have a bystander problem now. If anybody's remembered Czesław Milosz's The Captive Mind, I've been rereading it for the last year or so, because it seems, and I, as family, I have a lot of, in the Philippines, I do pro bono for victims. And it baffles me how these things can happen. And I've actually met with many of the leaders in the country, how it's almost like an alternate reality. There's a Philippines where the elites inhabit this bubble where everything's great because we have a 7% growth rate where development is taking place, and we're proud about Filipinos. But the big battle is taking place in what my colleague Philip Medalla, who's with the Monetary Board, who was former dean of the School of Economics, said the big battle is taking place. The slaughter is taking place at the Class D, and contrary to popular perception, Duterte's base support comes from A, B, and C, the middle class and the ultra elite, because he guarantees them free protection of their property rights. They've been afraid because of the rise of criminality, and it's good for them to have security, peace, and order. It does touch their gated good communities. It's the reality they have to be within the comfort of the air-conditioned mall complexes that have seemed to proliferate all over the centers, urban centers. And so there's no empathy and there's no sympathy. Totally different from what it used to be under the Marcos era, where it was fewer things to track people. You had checkpoints. You had actual out impositions of these issues. I have differences with many of my colleagues, and so sure, I've been castigated by a lot of people too for taking this position, saying that I'm taking a political position. Don't. I'm victim counsel. I'm not affiliated with any party, but they use the strategy of, if you are a Duterte, you must be with the opposition party. And by default, you must be illegitimate. And so we're going to discredit what you say. It's been very difficult. Once it's almost as if there's a veil, there's a cognitive veil that the elites like to think, this can't happen to us. It only happens in the fringe. It doesn't really touch our reality. So it's very Czesław Milosz. It's the captive mind of what do you do when it's already the intellectual elites who are thinking this is still okay. And that's a big problem. I agree, because it's the same thing that has enabled so many strongman regimes to flourish. And it goes back to how the strategies of co-optation have been so well used in turning rule of law into rule by law. And I don't have an answer for it. I would like there to be more culture. I would like there to be more consciousness cultivated by the artists, by the poets, by the people who speak for the people. Because it doesn't seem to me that lawyers or human rights advocates, they don't listen anymore. The moment you're branded as you're a human rights lawyer, of course you're for the opposition. You don't know what it takes to build a country. Nobody's listening. And maybe we start listening a little bit better. And I don't know, I'm not trained to encourage how to be able to track that kind of deep learning. And I think it goes back to, at least in Northern Ireland, it is in the popular. It is in consciousness, in song, and literature, and theater, in the collective consciousness of the people. I would have to say right now in the Philippines, there is not a whole sense of the people. The landslides and basically my mother's birthplace, a few days ago from the massive storms, and was on the New York Times, but it didn't even make a blip in the Philippine media, because all preoccupied with standoff taking place between the opposition senator and Duterte. There is no sense of people. And I do agree. You have to get back what makes us human, and that's not something lawyers can speak to. It's what we will be able to, because, like I said, rights are dormant unless we actually know who we are as human beings, use them.
I think that's a good place. Do you want to make one more comment, Maurice? Or?
No, that
Okay.
we'll talk later.
Okay, great. So feel free to join us across the hall for food and further conversation. Thank you for coming. Thanks.